So I'll be dealing with the basics of Indian Evidence Act. I'll just start with the definitions of the that are contained in the Evidence Act. I'll start with fact. Fact means I'll just read the definition of fact in the as laid down in the Evidence Act. Fact means and includes anything, state of things, or relations of things capable of being perceived by the senses, any mental condition of which any person is conscious. So I'm speaking right now. You can perceive this through your sense of hearing. So I'm speaking is a fact. Now I'll just go to the another definition that is relevant. One fact is said to be relevant to another when the one is connected with another in any of the ways referred to in the provisions of this act relating to the relevancy of facts. How is a fact relevant to other fact? This courts usually decide. Now, let's say a accused is convicted, is not convicted, an accused is being tried for an offense of rape and under the provisions of POXO Act. So the accused tries to lead the evidence relating to the age of the victim. Court says, how is the age of the victim relevant in this case when we are trying for rape? So the accused says, I want to prove that the prosecutrix is not a minor, she's a major. And she's a major, and the act, the intercourse was consensual. But before the accused can prove that the act was consensual, he needs to prove that she's a major. Because if she's a minor, then her consent is immaterial, because a minor's consent is anyway immaterial in law. So the court will not consider that. So the fact that the act was consensual, that is a relevant fact for deciding the trial whether the rape was committed or not. So that relevant fact that the act was consensual can be proved only after the accused leads evidence to show that the victim was major. Only when he leads evidence and shows that the victim was major, then he can prove that the act was consensual, because the relevant part is the victim should be major. Only then consent is material. So that is a relevant fact. And that relevant fact will have to be proved prior in time before it can be proved that the act was consensual. Facts and issues. The expression facts and issues means and includes any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature, or extent of any right, liability, or disability asserted or denied in any suit or proceeding necessarily follows. Explanation. Whenever, under the provisions of the law, for the time being in force relating to civil procedure, any court records an issue of fact, the fact to be asserted or denied in the answer to such issue is a fact in issue. So the example I just gave you about a rape and a case of rape and a POXO Act, in that, what are the issues? What are the facts in issues? Is the prosecutrix a major? Was the act consensual? These are the facts which are in issue before the trial court, and the court will have to go through the evidence of the prosecution and the evidence of the defense and then come to a conclusion. So these are the facts that are in issue before the trial court. Now I'll just read the definition of document. Document means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means intended to be used or which may be used for the purpose of recording that matter. So anything in which any document or any material upon which anything is expressed or described, that will be a document. Let's say I'm sitting in a cafe with my friend. I tell him that, I'm thinking to sell my old bike for 10,000 rupees. He says that I want to buy a bike for 10,000 rupees. Now I pick up a tissue paper that is kept there, and I write that I sell my bike to X for 10,000 rupees. He says I accept, and he sign it and I sign it. So because both of us have expressed something on a piece of paper, on a material, that material becomes a document within the definition of Indian Evidence Act. Now, let's say he wants to go to the court. I'm not selling him, I'm not giving him the possession of that bike. He wants to go to the court. What will he have to prove? He'll have to prove that there was an agreement between the parties, that there is a document to prove that agreement between the parties, and he's relying upon that document to show that I should give him the possession of that bike. So he'll can he just take a photocopy of that, or he'll have to take the whole actual tissue paper? The tissue paper in itself is the primary evidence, because on the tissue paper originally we have written and we have signed it, so that is a document within the definition of Indian Evidence Act. That is a document. How is that relevant? That is relevant because the issue between the parties is, did we agree that the bike should be given to him for 10,000? And this, whether this is a document that can be admissible in evidence. Now, of course, that paper or that tissue will fall within the definition of a document. But is it admissible in law? That is a different facet. Now, there can be issues relating to admissibility. I may say that that napkin is, because it's a written agreement between the parties, that there should have been registered compulsorily. I can say that maybe the stamp duty is payable on this. If I raise these issues relating to the registration, that under the Registration Act it is compulsorily registrable, or under the Stamp Act that a stamp duty was to be paid, and if that is not done, then I can say that this document cannot be taken into evidence, and the court cannot rely upon this document to pass the judgment. So that is, in sum and substance, document, relevancy of that document, and its admissibility. I'll just refer to a judgment of the Honorable Supreme Court, RVE Venkatachalla Gounder versus Arulmigu Vishwasarva Swamy. The citation is 2003 8 SCC 752. In this case, the court has said that ordinarily an objection to the admissibility of an evidence should be taken when it is tendered and not subsequently. So if in the above example, if he's tendering that tissue paper, I should object to the document being tendered. I should object right then and say that this is not admissible because it's not compulsorily registered. It's the stamp duty is not paid, so this cannot be taken into consideration. The objection as to admission of a document in evidence may be classified into two classes. This is the same judgment I'm referring. An objection that the document which is sought to be proved is itself inadmissible in evidence. If a document is not registered or the stamp duty is not paid, it's not admissible in evidence. If stamp duty is not paid, the court will have to compound that document, send it to the appropriate authority. Stamp deficit will have to be paid. Then only that document can be relied upon. So this objection I should take immediately and say that this is not admissible in law, in evidence. And the second objection that can be taken is that the objection does not dispute the admissibility of the document in evidence, but it is directed towards the mode of proof, alleging the same to be irregular or insufficient. So there are two types of objection. I can say that the document itself is not admissible in evidence, or I can say that the document, though admissible, the mode in which the plaintiff has obtained the document is illegal, and that he should explain how he has obtained that document. In the first case, merely because a document has been marked as an exhibit, an objection to its admissibility is not excluded and is available to be raised even at a later stage or even in appeal or revision. So out of these two types of objection that I can take, one which is relating to the admissibility of the document itself, that I can raise at any time, that I can take in the first instance available or even in the appeal court, that this document could not have been relied upon by the court itself, and the order has been passed or the judgment has been passed relying upon this evidence, but this was not admissible. So the whole judgment will have to go away. In the second case, where I'll say that the document itself is admissible, but the mode in which it has been obtained is not proper or is improper, in that case, the objection should be taken before the evidence is tendered. And once the document has been admitted in evidence and marked as an exhibit, the objection that it should not have been admitted in evidence or that the mode adopted for proving the document is irregular cannot be allowed to be raised at any stage subsequent to the marking of document as an exhibit. Out of the two types of objections referred to herein above, in the later case, failure to raise a prompt and timely objection amounts to waiver of the necessity for insisting on formal proof of a document. The document itself, which is sought to be proved, being admissible in evidence, in the first case, acquiescence would be no bar to raising the objection in superior court. So when it relates to the second type of document, in which the document itself is admissible, but the mode of procuring that document is illegal or immoral, then I should raise the objection at the first instance available. And if I don't, then that will amount to waiver, and I cannot raise that objection at a later stage or in before a superior tribunal or a court. Now I'll just read the definition of evidence. Evidence means and includes all statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. Such statements are called oral evidence. All documents, including electronic records, produced for the inspection of court, such documents are called documentary evidence. So there are two types of evidence in that case: oral evidence and documentary evidence. Now, predominantly in criminal cases, the evidence is dependent upon the witnesses who come to the court. They enter the witness book and depose what the facts are, what has happened, and that is something what is called as oral evidence. The party or the witness comes to the court, deposes about a fact, that is oral evidence. In civil cases, predominantly, obviously, in criminal cases also there can be documentary evidence. There can be a doctor's report, a chemical analyst's report. In civil transactions, so far as civil transaction or civil cases are concerned, they are dependent on contracts between the parties or understanding between the parties, which is documented. So predominantly in civil cases, documentary evidence is given. Relevancy. Now sections from starting from 5 deal with relevancy and what is relevant under the Evidence Act. And I'll just go to section 6 of the Evidence Act that deals with res gestia evidence. Now, res gestia means that the incident that has happened or the crime that has been committed and the evidence, the oral submission by the victim is given to the witnesses present there. And the gap between that submission and that commission of offense is so small that the victim could not have made that up, that the victim could not have concocted a false story. That is what is called as res gestia evidence. In this case, in one case, what has happened was this case was also about rape. The allegation as such was the prosecutrix was kidnapped. She was taken in a van. In that van, there were about 10 people, and she was raped by two people, and others were also involved by they were fondling her and all of that. But this matter traveled up to the Supreme Court. The Supreme Court said the evidence of the prosecution is very shaky in the sense that the prosecutrix has changed her statements over time and again. When she knew the name of all the accused, but the name was not even mentioned in the FIR, all this was considered. The court also said that when the prosecutrix was taken away, she was raped. And after she came back to her mother and sister, she told these facts to her sister and mother, but the mother and sister were not examined by the prosecution. They should have been examined because soon after the commission of offense, the witness or the victim in this case gave the oral evidence to the mother and sister, they could have been the best res gestia witnesses because the time gap was so small that she could not have concocted a story or given a false or frivolous statement. And so that would have been relevant, but the prosecution failed to bring her mother and sister. So the benefit of doubt was given, they were let go. So that is what is called res gestia evidence. Now, there can also be motive, preparation, previous and subsequent conduct which are relevant of an accused person. Let's say a crime is committed, someone is murdered, the accused person realizes that the police has started investigation. He has a fear that I may be caught by the police. So he absconds. Now, this conduct of the accused person of absconding soon after the investigation had started is a relevant conduct. And the prosecution can definitely use this and say that, look here, the as soon as the investigation started and the accused felt that he may be grabbed by the police, he has absconded. So this conduct of the accused is a very relevant conduct as to show that he is an accused person. Now, the evidence, so far as documentary evidence is concerned, could be primary evidence, could be secondary evidence. Now, what is primary evidence and what is secondary evidence? I'll just start with section 61, which deals with proof of contents of documents. It tells us how proof of contents of a document are to be established. The contents of documents may be proved either by primary or by secondary evidence. Now, what is primary and secondary evidence? Primary evidence is section 62. Primary evidence means the document itself produced for the inspection of court. Explanation: where a document is executed in several parts, each part is primary evidence of the document. Where a document is executed in counterpart, each counterpart being executed by one or some of the parties, only each counterpart is a primary evidence against the parties executing it. So the original document, for example, in the earlier example I gave, that tissue paper in which we executed we both of us put our signatures, that piece of tissue is the primary evidence that is there. Now, what is this also deals with counterpart. What is a counterpart? Let's say a agreement is printed, not one agreement, two agreement is printed at the same time. Both are original, both come from same source. Then the and one is signed by one party, other is signed by the other party, and they exchange the documents, the original signed, they exchange with each other. So these are counterparts of each other. They are not secondary evidence of each other, but they are counterpart because they come from same source. So they are both primary evidence of each other, and whoever executes that document, that is a primary evidence against the person who has executed that document. If I am the transferor, you are the transferee. If I sign it, the copy signed by me is a primary evidence that can be used against me. The transferee, you sign it for the transferee. The copy which is signed by you, or the original which is signed by you, rather, that original that is signed by you is a primary evidence that I'll use against you in a court of law. So this is what primary evidence is. Now, there's also one more thing where a number of documents are all made by one uniform process, as in the case of printing, lithography, or photography. Each is primary evidence of the contents of the rest, but where they are all copies of a common original, they are not primary evidence of the contents of the original. So, if this is an original document, if I take 5 Xerox of this, all the 5 Xerox will be primary evidence of each other, of the each Xeroxes will be primary evidence of each other. But this original is a primary evidence, and that Xerox cannot be used as primary evidence. That Xerox copy is primary evidence of all the other sets of Xerox that was taken from this source. That is the original document. That is or secondary evidence as far as this original is concerned. Now, what is secondary evidence? Section 63 deals with secondary evidence. Secondary evidence means and includes certified copies given under the provisions herein after contained, copies made from original by mechanical process, which in themselves ensure the accuracy of copy, and copies compared with such copies. If I take a Xerox copy of this, now that has happened before because of a photostat machine. And that photostat machine makes sure that whatever is here is the same thing comes in the other Xerox copy. So in that sense, that is the secondary evidence because it has happened through a mechanical process, which assures the accuracy of the copy. Copies made from or compared with the original. Let's say instead of taking a photocopy, I write it down from the original. Then the one which is written, handwritten, is also a secondary evidence, provided it is compared to the original. Counterparts of documents as against the parties who did not execute them. So if a counterpart is there, I'm executed the one copy, original copy, and the other party has executed the other original copy. The party who has not executed the agreement, against him, this is a secondary evidence. Oral accounts of contents of a document given by some person who has himself seen. So, secondary evidence will also include oral evidence, which the witness will give that yes, this is the document, this was executed by him on so and so date. That statement by the witness is also a secondary evidence. Let's take an example. I say that I want to sell my house to Malvika. Malvika says, "Okay, I want to buy your house." We execute a agreement for sale and we get it registered with the office of sub registrar. Now, she in because of the execution of that agreement for sale, she pays me 10 lakh rupees. Now, after receiving 10 lakh rupees, I think I don't know, maybe I shouldn't sell my house to Malvika. So I said, you know what? I don't want to sell my house to you, and I don't want to return your money also, and I will not give you the possession of the property also. Now, the agreement that is executed and registered with the sub registrar, the original agreement is returned to Malvika. That original agreement is a primary evidence. Now, let's say that original agreement is misplaced by Malvika or that is lost. That is lost. So the primary evidence is gone. She has a photocopy of that agreement. Can she go to the court and say, this is the photocopy of the agreement that, for sale that was executed between the plaintiff and defendant? You please order him a specific performance and tell him to give me the possession of that property. She cannot do this because I will object and say that this document, which the plaintiff is trying to rely upon, is not a primary evidence, but is a secondary evidence. And before a secondary evidence can be led, the party has to establish why the primary evidence is not available, because primary evidence is the best evidence available. So so Malvika as a plaintiff has to establish why the primary evidence is not there. She has to say that the primary evidence is lost or misplaced. I have made this police complaint. See here, look here. I've made this police complaint because I've lost or misplaced the original agreement for sale. I have made a paper publication and I've said that whoever if receives the original, please give it back to me. I have taken all the measures and to retrace that original. I have been unable to do that. Now, I am requesting the court to consider the photocopy as a secondary evidence and let me allow me to tender this. Is the stand she'll have to take, because secondary evidence cannot just be taken. First, you have to give either the primary evidence, or you have to in your averments, in your pleadings, you have to say that the why primary evidence cannot be given and why the court should allow the secondary evidence to be given. But in this case also, there's one more objection that as a defendant I'll take. I'll say that since this document, this agreement was for sale was executed and registered with the office of sub-registrar, she cannot rely on merely photocopy, but she has to produce the certified copy from the office of sub-registrar. Now, of course, this is also dealt in section 57 of the Registration Act. I'll just deal with that later. I'll come to that. But she has to produce that certified copy because that certified copy is definitely on a higher pedestal than just a normal photocopy. So she has to produce that certified copy and say that the original is lost. I took all the steps I could to get it, trace it back, but I'm unable to trace it back. Here's just a certified copy from the office of sub-registrar. Please allow me to use this as a secondary evidence. And in that case, that secondary evidence may be allowed. But let's say that Malvika's luck is so bad that the original is lost, the office of sub-registrar is flooded, and the copies from the office of sub-registrar is also gone. Then what can she do? In that case, she can say that, look here, I have filed a complaint with police. I have given paper publication. The office of sub-registrar was flooded due to rain, and the copy which was available with the sub-registrar is also lost. Now, please allow me, this is the only photocopy I have. Please allow me to tender this in evidence and plead my case. In that case, in that extraordinary circumstances, only then she'll be allowed to use this ordinary photocopy as a secondary evidence. Now, I'll just read section 64 of the Indian Evidence Act, which deals with proof of documents by primary evidence, which says that document must be proved by primary evidence except in cases hereinafter mentioned. So, how is a document to be proved? A primary evidence of the document is to be given to the court so that the court can satisfy itself that yes, this is the primary evidence, and then the court can decide on it. Cases in which, section 65, cases in which secondary evidence relating to documents may be given. Secondary evidence may be given of the existence, condition, or content of a document in the following cases: where the original is shown or appears to be in the possession of or power of the person against whom the document is sought to be proved, or of any person out of reach of or not subject to the process of the court, or of any person legally bound to produce it, and then after the notice mentioned in section 66, such person does not produce it. So in the above mentioned example, let's say if the original agreement for sale, it should be with the plaintiff, but let's say in this case it's with me. If I have the original agreement for sale, and then what can she do? Then she can say to the court, look here, I have given a notice to the defendant. Notice is in the defendant is in the possession of original agreement for sale. As per section 66 of the Evidence Act, I have given him a notice to produce the original, and he has failed to produce the original, or he is refusing to produce the original. So this court may consider that I may be allowed to lead my secondary evidence by way of a copy of a certified copy from the office of sub registrar. This is what this means. Now, clause B, when the existence, condition, or contents of the originals have been proved to be admitted in writing by the person against whom it is proved, or by his representative in interest. So that is the existence of it, or the contents have been proved because I have admitted. Let's say if I admit it, I say yes, an agreement for sale was executed between the parties, then it's an admitted fact, and she can just prove it by way of a secondary evidence. When the original has been destroyed or lost, or when the party offering evidence of its contents cannot, for any other reason not arising from his own default or neglect, produce it in reasonable time. So, of course, if it's lost, destroyed, if something like that happens, then party may be allowed to bring in secondary evidence. When the original is of such a nature as not to be easily movable. If the primary evidence is a big rock on which I have written something, because if I write something on a, let's say there's a big piece of rock, I write something on it. Because I have written something on it, it becomes a document. Now, the original rock is the primary evidence. Now, the plaintiff cannot be expected to carry that big rock and bring it to the court. So, the party or the plaintiff may say, here is the original thing. That cannot be brought to the court. Here is a photograph of this rock. You please consider this as a secondary evidence. When the original is a public document within the meaning of section 74. So if it's a public document and a public body has the possession of the original cannot be produced in every each and every case. So in that case, a certified copy will do a secondary evidence as secondary evidence. When the originals, oh, sorry, I think I left F. When the original is a document of which a certified copy is permitted by this act or by any other law in force to be given in evidence. So if the law says that, if an act says that, secondary evidence can be given, then court will consider it certified on based on the certified copy. When the originals consist of numerous accounts or other documents which cannot conveniently be examined in court, and the fact to be proved is the general result of whole collection. If there are a lot of originals, and it's not possible to bring it to court, there's some difficulty, then it can be explained to court and secondary evidence may be led. Now, I'll also read section 144 of the Evidence Act. This is relevant, so I'll read this. Evidence as to matters in writing. Any witness may be asked, placed under examination, whether any contract, grant, or other disposition of property as to which he is giving evidence was not contained in a document, and if he says that it was, or if he is about to make any statement as to the contents of any document which, in the opinion of court, ought to be produced, the adverse party may object to such evidence being given until such document is produced or until facts have been proved which entitle the party who called the witness to give secondary evidence of it. Explanation. A witness may give oral evidence of statements made by other person about the contents of the document if such statements are in themselves a relevant fact. So, in the example given in which Malvika wanted to buy my house, can, if original is lost, can she go to the court and say, I executed and registered an agreement for sale with the defendant. I am ready to give oral evidence about it. You please direct the defendant to specifically perform the contract. No, she cannot, because section 144 is clear. If a party wants to lead evidence, oral evidence about a document, about the contents of a document, and if courts ask or the adverse party objects to it, then the party who wants to lead that evidence, in this case Malvika, she'll have to say that. She'll have to bring the document on record before she can give her oral evidence to that. And I'll just refer to a Supreme Court judgment in which they have dealt with documentary evidence. Sunil Mehta versus State of Gujarat, 2013 9 SCC 209. Documentary evidence would similarly be evidence only if the documents are proved in the manner recognized and proved for under the Evidence Act, unless, of course, a statutory provision makes the document admissible as evidence without any formal proof thereof. Suffice it to say that evidence referred to in section so and so must, on a plain reading of the said provision and the provisions of Evidence Act, be admissible only if the same is produced And in case of document proved in accordance with procedure established by the Evidence Act, which includes the right of parties against whom this evidence is produced to cross examine the witnesses concerned. So, plain reading of it says that if a party wants to prove a document, that party has to produce the document before the court, and then that witness will give evidence to prove the contents of that document. The defense will get the opportunity, defendant will get the opportunity to cross-examine the plaintiff, and all of this happens. After this, the court will decide upon the evidence and the probative value that that evidence carries. So a document can also be proved by the handwriting or the signature. So this is a judgment of the Supreme Court which deals with handwriting of a document. Ramji Dayawala and Sons Private Limited versus Invest Import 1981 AIR 2085. Mere proof of the handwriting of a document would not tantamount to proof of all the contents or the facts stated in the document. If the truth of the facts stated in a document is an issue, mere proof of the handwriting and execution of the document would not furnish evidence of the truth of the facts or contents of the document. The truth or otherwise of the facts or contents of the document so stated would have to be proved by admissible evidence, that is, by the evidence of those persons who can vouch, say, for the truth of the facts in issue. So, if Malvika goes to the court and she says that this agreement was executed between us, so if I say, yeah, I admit it, there was an agreement for sale which was executed by between the parties, but this by itself will not prove the document. This will only prove the execution of document. So if she wants to prove the contents of the document, she will have to lead evidence and show that whatever has been recorded in the document, that she'll have to prove. Because if you read the section 3 may prove, disproved, and not proved, if Malvika's case is that there is an agreement, she has to prove it. And if she fails to prove it, that fact is not proved. I don't have to disprove that. So before she can say that, or merely because I admit that the agreement was executed, that does not discharge the burden on her to prove the contents of the document. The contents of the document will have to be proved by her. She'll have to say that, look here, this is the document, the execution is proved. Now I just have to prove the content. I was the party present when this was executed. The contents of it is so and so and so and so. I'll just refer to a judgment of Supreme Court in which the party tried to rely upon document which was simply set a mark. It was not proved. The court said, Seth Taraji Khimchand versus Yelamarti Satyan alias Satya, AIR 1971 SC 1865, equivalent citation is 1972 4 SCC 562. The plaintiff wanted to rely on exhibit so and so and so and so, the day book and the ledger respectively. The plaintiffs did not prove these books. There is no reference to these books in the judgments. The mere marking of an exhibit does not dispense with the proof of documents. So, merely if a document is marked, it's not exhibited, it's not taken into evidence. If merely she tenders a copy of a certified copy of the agreement for sale in the court and says that, and the court marks it, says that yes, this agreement for sale is marked as exhibit so and so, that does not prove the document itself, and she'll have to lead evidence and prove the contents of the document. If she fails to do that, merely because the document is marked as an exhibit, that cannot be considered by court while deciding it finally. That is what this judgment says. Now I'll deal with one more judgment of the Supreme Court. This is Dr. Gurmukh Ram Madan versus Bhagwan Das Madan, 1998 7 SCC 367. This was a suit for partition. This was filed by one brother against another brother. He failed to show any evidence how he had contributed for the piece of land. The certified copy of the registered deed The trial court, he tendered a certified copy of the registered deed, and that deed was not, the trial court did not admit this in evidence on the ground that the absence of original had not been duly accounted for. So he wanted to place secondary evidence on record. Court said no. He has not proved why the primary evidence was not tendered or what were the reasons why the primary evidence was not tendered. So this secondary evidence, the certified copy, cannot be relied upon. Section 65F of the Indian Evidence Act states that secondary evidence is permissible. But what it means is, all that it means is that secondary evidence is permissible. Secondary is admissible notwithstanding the existence of the original when it is a document of which a certified copy is permitted to be produced by act or any other law. The document in question is not a public document, and the document could not have been let into evidence except after explanation as to non availability of original in the appropriate manner. So, in this case, the originals were not available. The document relied was not a public document, but a private document executed between private parties. Court said, how can we allow this? And court said the secondary, before secondary evidence can be led, you have to show why the primary evidence was not available, but there was nothing in the contentions or prayers or in the of the plaintiff. So this failed finally in the Supreme Court. Now there's one more Supreme Court judgment, Ashok Dhulichand versus Madhav Lal Dubey, 1975, 4 SCC 664. This was an election petition filed in which what has happened was there were a lot of leaflets that were prepared, Xerox copy of lot of leaflets, which had defamatory content against one of the contesting parties. So he filed a election petition and he said that tried to rely on that photocopy of leaflet and said this is published by the respondent and no other material was placed by him on record to indicate that the original was in possession of respondent. The appellant further failed to explain as to what were the circumstances under which the photostat copy was prepared and who was in possession of the original document at the time its photograph was taken. Respondent number one, the respondent obviously denied to having been in the possession or having anything to do with the leaflet. So the court said that no, this photostat copy of that leaflet is not admissible and we are not going to allow this. The next judgment is Magaraj Patodia versus R.K. Birla, AIR 1971, SC 1295, and equivalent citation is 1970 2 SCC 838. A document procured by improper or illegal means will not be a bar to its admissibility if it is relevant and its genuineness proved. So, when I initially talked about two types of objection, we can object to the admissibility of the evidence or the means by which the document is procured. The court says that a document procured by improper or illegal means will not bar it if it is relevant and its genuineness proved. So all you have to do is prove that it is genuine, prove that it is relevant, and the court will consider it. But while examining the proof given as to its genuineness, the circumstances under which it came to be taken into consideration, you have to prove that what was the circumstances under which it came to be taken into consideration. Next judgment is State of Haryana versus Ram Singh, AIR 2002 SC 620. Equivalent citation is 2002 2 SCC 426. This, the court said, as far as the provisions of the Evidence Act are concerned, a certified copy of the registered sale deed is admissible and evidence and does not need to be proved by calling a witness. Court said that certified copy is admissible in evidence. Of course, it's admissible as we have for secondary evidence, no issue in that. In this case, state of Haryana, AIR 2001 SC 2532. This was a land acquisition case. And in land acquisition case, how it works is if I have a land and that is being acquired by the government, the price of the compensation will be decided by the amount which is given to the lands which are near my land, so that, okay, my neighbor got paid so much, my neighbor got paid so much. So, considering all that fact, this person should be paid so much. That is how compensation under land acquisition is crystallized. In this case, what the Supreme Court said, comparable land acquisition act matter, comparable sales method was adopted to determine the amount of compensation. Certified copy of the agreements executed by my neighbor. I produced it and I said, look here, my neighbors, all these are my neighbors, and they have got this kind of compensation. And based on these comparatives of all these compensation given to my neighbors, I should be given a compensation. The court said, yes, this can be taken into consideration. Court said, certified copy of the registered agreement for sale is admissible without examining of the parties to the document. So I did not call the parties who executed that. And as far as land acquisition for compensation under land acquisition is concerned, that can be based on the comparative statement and comparative how much my neighbors are getting. I can also be given. The next judgment is Rakesh Mohindra versus Anita Bailey. In this, the court has dealt with the preconditions of leading secondary evidence. The citation is 2016 16 SCC 483. The preconditions for leading secondary evidence are that such original documents could not be produced by the party, relied upon such documents in spite of the best efforts, unable to produce the same document in spite of the best efforts, unable to produce the same which is beyond their control. So a party will be allowed to lead secondary evidence when after best effort they can show that they took their best efforts, but in spite of that they are not able to trace the originals or the primary evidence. The party sought to produce secondary evidence must establish for the non-production of primary evidence unless it is established that the original documents sought to be used, secondary evidence in respect of that document cannot be accepted. So, if I want to lead secondary evidence, I have to prove why the primary is not available. Only then can secondary evidence be permitted. Next judgment is M. Chandra versus M. Thangamuthu, 2010 9 SCC 217. The secondary evidence must be authenticated by foundational evidence that the alleged copy is in fact a true copy of the original. It should be emphasized that the exceptions to the rule requiring primary evidence are designed to provide relief in a case where a party is genuinely unable to produce the original, though no fault of the party. So, court says that you have to, in your pleadings, make a foundation why the primary evidence is not available and why secondary evidence should be allowed. Now, I'll deal with public documents and private documents under the Evidence Act. So, public document is dealt by under Section 74 of the Indian Evidence Act. The following documents are public documents. First, documents forming acts or records of acts of Roman one is of sovereign authority, of official bodies and tribunals, of public officers, legislative, judicial, executive, or of a foreign country. And second is public records kept of private documents. So these are two illustrations given are public documents. What what is private document? Section 75. All other documents are private. Let's say the example I had given earlier. There's an agreement for sale between me and Malvika, and that has been executed and registered with the Office of Sub-Registrar. So merely because it's registered with the Office of Sub-Registrar and a copy of that is retained by the Office of Sub-Registrar Does that mean that the agreement executed between us is a private document or is it a public document? Because the sub registrar is a public officer. That is the question that will come to one's mind. So the document executed between me and Malvika, since we are private parties, the document is also a private document and it does not become a public document. Because if you see the definition of public document, only the acts or records of the governed sovereign authorities or official bodies of tribunals or public officers is a public record. But that agreement is executed between us. We are the parties concerned. The government authority or the public authority has nothing to do with it. So that is not a public record but a private record. Now, of course, all the other documents which are not public records are private documents. I'll deal with the judgments of Bombay High Court in which they have dealt with the whether the document is a private document or a public document. The first judgment is Purushottam versus A.N. Jog. The citation is 2005, 1 Maharashtra Law Journal 426, and the equivalent citation is 2005, 2 ALMR 379. The court said that merely because the deed of assignment is registered with the competent authority, that deed itself would not partake the nature of a public document. It will continue to be a private document. Since because it's executed between private parties, it will retain the it will be a private document. This was also followed by Bombay High Court Nagpur bench in Vittal Rao alias Pandharinath and others versus Domaji Pandurang and others. Second appeal number is 62 of 2004. Contention was that the deed of cancellation being duly registered, that document was a public document as contemplated by Section 74 of the said Act, and hence it could be proved as a public document. So this a deed of cancellation was registered with the sub-registrar. So they were trying to prove it that it's a public document and they just wanted to submit a certified copy. The court said that the submissions cannot be accepted. The deed of cancellation is a document executed between two parties merely. So these documents are executed, that is signed by private parties. So since these are executed by private parties, this does not become a public document. Mere registration of deed of cancellation executed by private party cannot by itself result in such document getting a character of a public document under section 74 of the said act. The deed of cancellation cannot be treated as a public document under section 74 of the said act. So court said that this is what you're trying to rely upon is a private document. So you'll have to prove the contents as if it's a private document. And you cannot say that this is a public record. So here's a certified copy. Please consider this as an evidence and please, let's proceed. Court said that merely because it's registered, the Registration Act requires the document to be registered, so it's registered. But the document is executed between two private parties. It will still retain the value of a private document, and you cannot lead evidence and say that this is a public document and the court will consider it. This was also considered in one of the Guwahati High Court judgment, Bidhan Paul versus Paresh Chandra Ghosh, AIR 2002, Guwahati 46. Only those public records which keep the private documents and not the copies of the private documents are treated as public documents within the meaning of section 74 subclause 2 of the Indian Evidence Act. So if a will is executed, registered and kept with the registrar, the copy of the will that can be considered as a public document. But if the document is merely registered with the sub-registrar, that will not become a public document by itself. Does a certified copy of the evidence of a registered deed of attorney, deed of power of attorney, is not a public document and is inadmissible in evidence. So they were trying to say that this power of attorney, since it's registered with the sub-registrar, this will be public document and court may rely upon. The court said no. This is a document which is executed by a private party. This is merely registered with the sub-registrar. So this will not become a public document. This is a private document. I'll just read one section of Indian evidence which is relevant according to me. That is section 136. Judge to decide as to admissibility of an evidence. When either party proposes to give evidence of any fact, the judge may ask the party proposing to give the evidence in what manner the alleged fact, if proved, would be relevant, and the judge shall admit the evidence if he thinks that the fact, if proved, would be relevant and not otherwise. So, if you remember the example I gave you, the first example where a case of rape and proxo is there against the accused person, and he wanted to lead evidence to prove that the age of the prosecutrix or the witness is above 18 and she's a major. Then court will ask, how is this relevant? You are trying to prove the allegation is of rape. You are trying to prove the age of prosecutrix. How is this relevant? So the defense of the accused is that the act was consensual. But before that evidence can be led, the relevant part which the accused will have to prove is the accused is major. So before that can be done, he will have to prove that fact that she's a major, and judge will decide whether the fact that the accused person is trying to prove is relevant. And if the court thinks yes, this is relevant, if the accused is able to prove that the prosecutrix or the victim is a major and the act was consensual, then the accused will get the will this will not be rape or for that matter come under the POXO Act. In that case, the fact that the prosecutrix or the witness or the victim, I'm sorry, is age, the fact of the age is relevant, and the court may allow that. If the fact proposed to be proved is one of which evidence is admissible only upon proof of some other fact, such last mentioned fact must be proved before evidence is given of the fact first mentioned, unless the party undertakes to give proof of such fact and the court is satisfied with such undertaking. So I can say, as the defense counsel for the defense, I can say my defense of the accused is that the act was consensual, and I will prove that the victim is a major. But before I prove that, I undertake to prove that the victim is a major. But before that, I'll prove that the act was consensual, and I'll undertake to prove that the victim is major. The court, based on my undertaking, may say that, okay, fine, I'll consider the fact of consensual act first, and then later on, you prove the fact that she's a major. If the relevancy of one alleged fact depends upon another alleged fact being first proved, the judge may, in his discretion, either permit evidence of first fact to be given before the second fact is proved, or require evidence to be given of the second fact before evidence is given of the first fact. So the discretion is with the court. The court will say, no, first you prove that she is a major, and then I will let you prove that the act was consensual. Or the court may say that, yes, you prove that the act was consensual, and then we'll consider, or then you prove that the victim or the prosecutrix is a major. Because if the victim or the prosecutrix is not a major but is a minor, her consent is immaterial. I was just reading the recent Supreme Court judgment order in which they have suspended the execution of sentence on an accused person. It was also a POXO case. They were minors. They had a love affair. They had a consensual. They had sex. Allegation of rape and under POXO Act case was made out. He is behind bars for last almost 3 years. The case traveled from Madras High Court to the Supreme Court. The Supreme Court said that these were parties who were in love. The The accused is in custody for almost about 3 years, and the appeal has traveled up to this court. So we are suspending the execution of the sentence of the some 10 years imprisonment he was given. And court said will consider this, but let the execution be stayed till then. Now, as far as under IPC, consent is concerned of a person who is a minor. I'll just go to section 375 for a moment, which deals with rape. Rape. A man is said to commit rape if he penetrates his penis to any extent into the vagina, mouth, urethra, or anus of a woman, or makes her to do so with him or with any other person. If you see them first, secondly, thirdly in that section, the relevant one is sixthly, with or without her consent when she is under 18 years of age. So if you do it with or without the consent and she's less than 18 years of age, that consent is immaterial. This was also dealt by the Supreme Court in one case. It's just mentioned here, so I'll just read it. When the girl is below 16 years, her consent is immaterial. This citation is Bishnu Dayal versus State of Bihar, AIR 1981, Supreme Court 13. Supreme Court said that when the girl is below 16, her consent is immaterial. There's also one more citation. I'll just say that before I conclude on this topic. State of UP versus Manoj Kumar Pandey, AIR 2009, SC 711. Merely because the victim was more than 16 years of age, that cannot be a ground to hold that she was a consenting party. So if she's less than 18, her consent is immaterial. So just to explain why that was irrelevant, I've just gone through that. I'll just read one section only from the Registration Act 1908, which is relevant because this deals with private document and public document. I'm reading is section 57 of the Registration Act 1908, registering officers to allow inspection of certain books and indexes and to give certified copies of entries subject to previous payment of the fees payable in that behalf, the book numbers 1 and 2 and the indexes relating to book number 1 shall be at all times open to inspection by any person applying to inspect the same, and subject to the provisions of section 62, copies of entries in such book shall be given to all persons applying for such copies. So what is relevant is they don't give the whole document that was executed between the parties. The sub-registrar's office maintains these diaries or these books in which they write what agreement was executed. They take sign of the party executing it, where takes the original. So this record maintained by the office of sub-registrar is a public document, but not the agreement that is executed between the parties. Subclause 2. Subject to the same provision, copies of entries in book number 3 and in the index rating shall be given to the persons executing the document. So, book number 3 is relating to wills and testamentaries. So, as far as testamentary matters are concerned, they gave it only to the persons executing the documents to which such entries relate or to their agents and after the death of the executants, but not before to any person applying for such copies. Subclause 3. Subject to this same provisions, copies of entries in book number 4 and in the index relating thereto shall be given to any person executing or claiming under the documents to which such entries respectively refer or to his agent or representative. Subclause 4. The requisite search under this section for entries in book number 3 and 4 shall be made only by the registering officer. And subclause 5, which is very relevant, all copies given under this section shall be signed and sealed by the registering officer and shall be admissible for the purpose of proving the contents of the original document. So, under the Registration Act, section 57, subclause 5, it says that this documents which are registered with the registrar, if a certified copy is given, they can be tendered in as evidence, and that's why they are relevant and admissible in evidence. That's about it. I like to conclude it. I'll be open to questions now.
Ashish, there's one question that what
Right.
is the process, the court process of
Hmm.
um, objecting the admissibility?
You have to when the document. Let's say I'm for the plaintiff and I'm tendering in court some evidence, right? You see, this evidence is not admissible for some reason, or in arbitration matters, let's say, and a party says that these are the documents I'll be relying upon, and they give a list of documents on which they'll be relying upon, and I know that this document is not admissible in evidence, maybe for the reason that it's not sufficiently stamped, or the registration is not there, or the manner in which it is obtained or procured is illegal, immoral, then I have to object to that. Then and then I should tell to the court that, look here, this evidence or this document is not admissible in evidence. This cannot be taken. And then the court will record my statement, say that the counsel for the defendant or the for the respondent has objected to this document, and the court may mark it. Court may definitely mark that document, but the party who wants to rely on that document will have to prove the document, will have to prove. But if it relates to obviously stamp duty, then the court will have to just impound the document and send it. Then there's a question of marking it and exhibiting it. But if it's procured illegally or immorally, the court will take my objection and say that the plaintiff will have to prove, and this is subject to the objection of the counsel for the defendant or respondent, whatever the case may be.
The next question is, can you shed some light on what is circumstantial evidence?
Circumstantial evidence is where there are no direct evidence available. There are only circumstances. Let's say a husband and wife, they have recently got married. Now the husband is, harassing the wife for whatever dowry, or she wants a car or something like that. She commits suicide. Okay. Now, of course, there's a presumption under 113 or something like that of the Evidence Act that because the death has occurred within the 7 years, the this could be dowry death. So that's there. But there are also other circumstances around this. There are demands for dowry. So the father or the brother of the victim or the wife may say that this was not suicide, but this was murder by the husband. And these are the circumstances which we feel are very suspicious. They should be investigated. And these are circumstantial evidences available. Let's say there's a message from the wife to her father or her brother saying that my husband tortures me, or she told that to her brother, then these are circumstances available. There's no direct evidence because there's no witness available. If a husband kills his wife in his own house, hangs her to the ceiling fan, there's no witness available. There's no direct evidence available. There's no one who can come to the court and say that, yes, I have seen the husband hang his wife and he has committed murder. So there's no direct evidence as such available. There's only circumstances which are suspicious in nature, which are gravely suspicious in nature. And the concerned party, whoever he may be, they may be the state or the private parties, which may say that these circumstances are obviously something that needs to be looked into, investigated. Please consider that this is not suicide but murder, and these are the circumstantial evidence available, and those are the circumstantial evidence, not direct evidence, but evidence which can be considered by court.
As such, regarding the power of attorney and assignment deed, you had said, I have one query. Suppose one person promises me that the another developer has confirmed all of the right by assignment deed and the power of attorney, and such he executes one agreement with me, stating one clause in that the other developer has assigned all the work and also given
Right,
power of attorney, but he has not
right.
attached that both of the document. And
Mm,
if now I get the
mm,
certified copies from the sub
mm,
registrar, is it
mm.
possible for me to submit this in the court?
You should have what you should have done is, because if you do it through banks, banks will first of all take all the documents, scrutinize it, and do it. But let's say in your case, you have not done it, you have privately done it. Of course, because you are not a party who has executed that document. You are not the party who is in possession of it. So you may give a notice on the developer and say, you please produce the originals in court. And if he doesn't produce, you can of course rely upon the copy and ask the court to allow you to lead secondary evidence. Of course, you can do that.
Because the such clause is mentioned in the agreement that he
Right.
has executed such
Mm.
assignment deed and the another developer has given him a power of
Right.
attorney.
Right.
So if I get such documents from the sub registers, so I
Right.
will be in the I will be in the position to
Right.
take the advantage of that.
Right.
Sir, how
Yeah.
is exception to a valid contract coercion undue influence proved?
Mm. No, let's say if I and you are the executing parties. If the cost of my house is 10 crores, but in the agreement it's only 1 crore, and you go for specific performance because I'm not handing over the possession, and you say to the court, look here, we have an agreement, now he's refusing to give me the possession. I'll say that the look at the cost of the house, or look at the cost of the house or the area in which this house is. There is no way possible that the price which is mentioned in the contract is the correct price. So I'll say that the that Malvika had influenced me and said and executed this document, forced me to sign it, and therefore this is not admissible. This is illegal, void, and this cannot be relied upon.
Ashish, any tips for the students they are going to appear for their final exams? How to? Last time also I had asked you, but still today's topic, if there is
Uh,
any tip.
as far as I go, I have always tried to read and understand it, because this is not something you are not in your 12th grade where you study and after the exam this is not going to matter. This is something which will you will this will help you for the rest of your life. So read it, please try to understand what the concept is, because no matter what happens 5 year, 10 year down the line, these concepts, if you understand them now, this will really help you. Please read them with a broader understanding that this will forever in your lifetime help you, and not read it just to pass the exams. Because I mean, obviously, we all have done that, read the jhabwalas and all, but please, if possible, try to understand the concept or the idea of the act or the code, whichever you're reading. Thank you for having me, Malvika. Thank you so much.